Good afternoon, everyone, and welcome to this week's Business in 2025 webinar presentation. My name is Carrie Langen, and I'm today's moderator. I want to take a minute to go over a few housekeeping items before we get started. Please enter your questions using the Q&A box located at the bottom of your screen, and our panelists will do their best to answer any questions as time permits. Once today's webinar has ended, we would appreciate you taking a moment to complete our survey. Your comments and suggestions are important to us and provide us with topics for future presentations. I will now go over today's agenda and introduce our panelists. First, we have Catherine Hajar from our New York City office. Kate will be discussing a Trump administration memorandum on ensuring transparency in higher education admission. Next up, we will have Samuel Wiles, also from our New York City office. Sam will be discussing a position taken by the National Labor Relations Board, acting general counsel, regarding the state's ability to take on the NLRB's labor relations oversight. And last, but certainly not least, we have Lindsay McKenna joining us from our Buffalo office. Lindsay will be providing us with an overview of the Electronic Wills Act. I will now turn the program over to Kate. Kate?
Thanks, Carrie, and good afternoon, everyone. In the roughly 10 minutes we have this afternoon, I'm going to outline a new directive that's come from the Trump administration aimed at higher education institutions nationwide. And next slide, please. On August 7th of this year, the administration issued an executive memorandum that is called Ensuring Transparency in Higher Education Admissions. And this memorandum stems from the administration's priorities with respect to race in admissions following the Supreme Court's decision in Students for Fair Admissions. And it directs the Secretary of Education to implement new regulations aimed at requiring colleges and universities to provide more admissions data to the National Center for Education Statistics and its IPEDS data collection program. The memorandum further directs that this information be open to the public and that colleges and universities provide data from the previous 5 years. Next slide. So what does this memorandum say? It directs the Secretary of Education to, within 120 days of August 7th, expand the scope of required reporting to provide adequate transparency into admissions, and to that end, directs the Secretary to increase accuracy checks of the data that institutions submit to the IPEDS data system. It mandates the Secretary further revamp the online presentation of that data to make sure that it is easily accessible, intelligible, as presented to students and parents. If necessary, the Secretary is to overhaul the data collection portal entirely to remove inefficiency and better streamline the process to more efficiently organize and utilize the data received from institutions. Clearly here, the administration's priority is to make sure that this data is accessible to lay students and parents who are looking for it. Next slide, please. But shortly after this memorandum was issued, the department rather, issued a notice seeking public comment. And in that notice of public comment, it indicated some further details about what types of data and from whom it's going to collect this data. In that notice, it stated it plans to seek data based on not just students' race, but also sex, high school GPA, test scores, time of application, and the types of application, meaning early decision, early access, or regular admission, ranges of family income, Pell Grant eligibility, parental education, and financial aid status, among other things. The notice, again, this is the notice of public comment, signaled that a new IPEDS survey component called the Admissions and Consumer Transparency Supplement would be created and would be a means to collect this further data, but not necessarily every institution would be required to participate in this new survey. Next slide, please. In the notice, there's an explanation that four-year institutions with selective admissions, it doesn't define selective admissions, but selective is the word used in the notice, that these four-year institutions, as opposed to trade schools and community colleges, have an elevated risk of noncompliance with civil rights laws, according to the administration. Further, an elevated risk of noncompliance in awarding scholarships because of their selectivity. And it's their goal, it would seem at this time, to subject those, quote, selective institutions to the new survey component. The new survey component would seek data on undergraduate students, graduate students for the 5 prior academic years to establish a baseline of admissions practices from before the Supreme Court's decision in Students for Fair Admissions. Next slide. The notice seeks public input in 3 areas. There are 3 questions posed to the public here. The first being whether there are certain academic institutions or characteristics of certain academic institutions that make them at high or low risk of noncompliance with civil rights laws, to help the department identify whether it should narrow or expand the scope of institutions that would be subject to this new survey. Again, the survey is the method of collecting this data. The second question posed to the public is whether open enrollment institutions are community colleges, trade schools, whether they are at risk of noncompliance with respect to scholarship awarding practices, and whether those practices provide preferential treatment based on race. The third question posed to the public is feedback on the anticipated time it would take to collect and submit data, this new expanded scope of data requested by the new survey. This notice and comment period is going to remain open until October of this year. And the takeaways from this memo at this time should be as follows. What does this mean? This means that colleges and universities now should be, or start preparing if they're not prepared already, increased government oversight over their admissions practices and also their institutional aid practices, their scholarship practices. Another takeaway from this memo is that the IPEDS data, this new survey component, will be collecting data that is broader. It's going to be presented in a more accessible way, meaning that colleges and universities should also plan, or it's very likely that they will see new and more complaints from students and parents who are going to be presented with this data in a new manner. Complaints from the public are possible, as well as those complaints and inquiries coming from the department itself. So this is a new and evolving area. Again, this notice and comment period will remain open for a few more weeks, after which we may see some clarifying language from the department through regulation or guidance. If you have any questions about this memorandum or what this data collection initiative could mean for your institution, I'm more than happy to take those questions offline. Thank you, Carrie.
Thanks, Kate. We appreciate your insight on this. We will now turn the program over to Sam to discuss the National Labor Relations Board. Sam?
Hi, everyone. So I'm here to talk about recent statements or a recent statement from the NLRB's acting general counsel regarding his take on states kind of trying to infringe or at least move into areas where the board typically regulates in the absence of a NLRB quorum. So I'll just provide some background for those who don't know. So the NLRB's general counsel is the board's top prosecutor, if you will. So the general counsel is a presidential appointment position. It runs for 4 years. It's independent from the 5-member NLRB itself. And the general counsel is responsible for investigating and prosecuting unfair labor practices and generally just supervising NLRB field offices and how they process cases. So really sets forth, how the regions operate and how they should follow different enforcement guidance. The general counsel can also advocate for changes. He's also apply board precedent, but can argue for changes in law to maintain current board precedent, to overturn board precedent, really just setting forth what the enforcement priorities are for that particular administration. So the prior general counsel under the Biden administration was Jennifer Abruzzo, and she had a very broad interpretation of the National Labor Relations Act. Most things she saw were protected activity, and probably one of the most, if not the most, active general counsels in history. She sought and obtained changes related to union recognition, which was the board's CEMEX decision, separation agreements, which was the McLaren decision, and captive audience meetings and other similar changes in law. So when the Trump administration came in, one of the first things that happened was that she was fired from the role and replaced with the acting general counsel, who is still acting general counsel right now, who is Bill Cowan, who's a former board member himself and longtime board attorney, and has a great deal of experience working for the board. So his goal right now, in the absence of a board quorum, is to try to alleviate the board's workload and backlog of cases and keep the board functioning as normal as possible, given these unique circumstances where the board can't really function to its fullest extent. So that involves General Counsel Cowan. He's a proponent of settlement agreements and plans to re-empower regional directors to handle settlements. So that's allowing regional directors to not have to go through Washington to approve settlement agreements, so long as they comply with board standards. While he's only in the role temporarily, the president did nominate another management side attorney, Crystal Carey, who's a longtime board attorney and current attorney at Morgan Lewis, to be general counsel. Last we saw, she was at a nomination hearing in July before the Senate Help Committee, and then she'll presumably be up for a vote sometime in the near future. So I guess this is about states preempting, but I think there are two things that kind of go hand in hand with General Counsel, Acting General Counsel Cowan's guidance here. So he really views the NLRA as preempting state law, and I think he's trying to head off what states are trying to do, while also trying to make sure the board is functioning as much as it can to normal and seeking resolution among parties. So one of those, the critical issues, is the issue of deferral, which comes for parties who have collective bargaining agreements and grievance procedures and arbitration procedures related to those agreements. Under the last general counsel, deferral wasn't as common as it was, but General Counsel Cowan is trying to reprioritize deferral, meaning that the parties handle their grievances and disputes pursuant to their collective bargaining agreements, to the extent that they have those. In his view, that upholds the Act statutory scheme, while also appropriately using the agency's resources when there are cuts across the board coming for many departments in the government. So he wrote, the Act statutory scheme is supported when the parties to a collective bargaining relationship avail themselves of the negotiated dispute resolution machinery to resolve their differences. So you can see here that Bill Cowan, he really respects the Act, and he's in favor of enforcing it, which leads into preemption. I think since Trump fired the Gwen Wilcox, who was the Democratic board member, leaving the board with only 2 members, the board has not been able to function to its fullest extent, meaning that new decisions haven't come out, the board can't institute new regulations, and that a lot of decisions that are on appeal or on exceptions before the board are just waiting their turn in an ever building backlog, while cases are still processed and everything like that, but the board can't enforce orders or anything of that nature. But so states like California, Massachusetts, and New York have either passed or are considering legislation, what they would call trigger laws, where that the state's labor relations board would be able to fill in and govern private sector labor relations when the NLRB cannot. Well, I recently wrote an article covering this and can discuss that in more depth offline. Suffice to say that a lot of these pieces of legislation are probably a dead letter, and I think General Counsel Cowan views them very much the same. So in a recently issued statement, he wrote, recent measures by states due to the board's lack of quorum would very likely be preempted by the National Labor Relations Act. He went on, any concern that the NLRA is unable, the National Labor Relations Board is unable to fill its statutory duties under the act is unfounded. Indeed, the NLRB has largely been unaffected by the temporary absence of the board quorum. So he's really suggesting that these state laws are unnecessary, that the board will continue to operate as normal, and any challenges that come forward means that any challenge or any state law will likely be preempted by the National Labor Relations Act. So it's still interesting to see what states are doing and trying to advocate in the maybe not absence of the NLRB, but in its current state with its lack of quorum. So he's really advocating as an institutionalist that the board still has something to say even when it cannot say anything. So it's something to watch, but it's possible that the board will have a new quorum and get back to normal operations within the next few weeks, given the president's recent appointments. So happy to discuss if you have any questions, but thank you all for your time.
Thanks, Sam. We appreciate your update as always. I will now turn the program over to Lindsay. Lindsay?
Thank you, Carrie. Good afternoon, everybody. My name is Lindsay McKenna. As Carrie mentioned earlier, I do sit in our Buffalo office and I am a member of our Trust and Estates Department. So happy to help anybody with an estate plan. And I am here to discuss the newly passed legislation by New York State allowing for electronic wills. So this is applicable to New York residents only and allows for individuals who have a will prepared to sign that digitally or electronically with witnesses that are not in the same room as the testator. This was passed by the Uniform Law Commission in 2020, and then with COVID, it was pushed through several states, and New York will join 14 other states that allow for the use of electronic wills. The will, like I said, was passed by the Senate and the New York State Assembly, and it's anticipated that Governor Hochul will sign this into law, at which time it will become effective in 545 days. Next slide, please. The act, not only because of COVID and the need to stay with evolving technology, one of the sponsors of the bill said that New York, only 1/3 of New Yorkers actually have a will, suggesting that this act was necessary in order to help make wills, or the ability to have a will, more accessible for New Yorkers. Not only those in remote and underserved areas, but also from a cost perspective. The Electronic Wills Act does address the execution of wills only. It does not address the planning that goes into the preparation of a will. So even for those remote and underserved communities, they still need assistance with actually preparing the document. The Electronic Wills Act only addresses the actual signing of a will. Now we'll take a step back and say, why is a will even necessary? Under New York law, if you pass away without a will, New York will direct how your property is distributed. For an individual who's married with children, New York law says that approximately half goes to the surviving spouse and the other half goes to your children. Or if you are not married and do not have children, then your assets will pass up to your parents or to your siblings. A lot of times this does not meet with people's intentions, and they have other people or charitable organizations they want to receive a benefit from at their passing. And so in that scenario, a will is necessary. So the Electronic Wills Act will allow for, like I said, the digital execution of a document, allowing the testator, the person who created the will, to sit behind a screen and sign the document, while the witnesses, who are also remote, then say, yes, this person signed the will and now serve as a witness. This has some benefits to it. As I mentioned, the impetus behind having this document is that it's accessible. It'll be more accessible for all New Yorkers to have a will. It also, when the witnesses are reviewing the document and signing as a witness, there's a video depiction and a time-stamped audit trail of it. This in theory would help cut down on any sort of undue influence that may be occurring, or have a video recording to document the testator's capacity. The original will and this audit trail then gets filed with the New York State Unified Court System. So this all becomes a record and part of the will. So those are some of the good things that are coming out of this. A couple of things to be aware of if and when doing this. There are very specific steps in order to sign a will. When a will is signed with paper, with the oversight of an attorney, there's a presumption that it's validly executed. Under the Electronic Wills Act, you may be able to do this without an attorney. And there are very specific steps in the proposed statute as to how this will is signed. So the first thing is to identify what is an original will. If the testator is signing a paper document with the witnesses looking on virtually, we now have a paper will that's going to be witnessed remotely. So is the original that's to be filed with the Unified Court System in a digital format. There's a question of what we do with the original paper document that the testator signed. The statute is silent regarding this scenario as far as how the original is defined. The testator who signs the will can sign this anytime. They then have to present the document to the witnesses saying that they signed it. This can either be done contemporaneously with the testator signing the document, or it can be done at a later time. If it's done at a later time, once the witness is signed 30 days after, it gets filed with the Unified Court System. While the statute says that the filing has to occur within 30 days, there's no clear indication of when this 30 days begins. If the testator signs it before the witnesses and then acknowledges it to the witnesses, we don't know necessarily how long or when that will was signed. We also don't know if the statute is saying that the 30 days begins at that time. So this is an issue where fraud or undue influence can really come into play. The sponsors of the bill suggested that if this is done all at the same time, including having a notary available for a self-proving will, meaning the testator, the witnesses, and a notary are all together virtually in a room, the notary will be trained to keep an eye out for undue influence over the testator, fraud, or other capacity issues. However, the statute does not specifically require that this occur. Again, the statute says that they may have a notary available and have the witnesses at the same time. It is possible, as I already mentioned, that the testator could sign this at a separate time. So this is silent in the statute and ripe for litigation with respect to undue influence and fraud issues. In addition to all of this, the statute, while it said the reason that the statute will not be effective for 545 days after signed by Governor Hochul is that the burden has been placed on the surrogates courts to identify how to store these documents and to come up with policies as far as changing technology, data breaches, and lost passwords. Those issues all still remain to be figured out by the courts. Another issue is that I mentioned that 14 states, including New York, will allow for the use of electronic wills. However, there are at least 2 states currently that specifically disallow the use of electronic wills. So if an individual takes advantage of this statute and digitally signs a will and moves out of state, you will need to take into consideration whether a new will need to be drafted or prepared in compliance with the new state's laws. And then I've touched on it a couple of times, but the biggest issue that I have seen in looking through this statute that's not addressed is how an individual's capacity will be determined, how their signature will be deemed genuine for purposes of making sure the will is valid, and how to confirm that there's been no fraud or undue influence by a third party. When we are confined to the four sides of our screen, it's very difficult to read the room as far as if there's somebody off screen directing the testator to sign the document, or if they have been pressured to do this. Now, of course, this happens regularly, unfortunately, even with paper wills, but when you have oversight from an attorney and 2 witnesses in a room that can help walk a testator through not only the estate planning process, but then also through the execution of the document, there's some safeguards built in to identify these issues. Without having those safeguards in place, I think we're going to see an uptick in estate litigation. Now, some of these things we might be able to fix before the decedent passes away. But if not, if the electronic will is deemed invalid after the decedent passes away because it was not executed properly, or they didn't follow the statute specifically, the data trail is not included, there's no remedy. There's no remedy built into the statute, and there's no remedy because now the decedent has passed away, and we're in a position where we have to either use the default rules for distribution of the property or use the court system to construe a will that may not be valid. So while the intentions behind the Electronic Wills Act are good, and they're there to help all New Yorkers create a will and make sure their intention is met, I think there are still a lot of things that New Yorkers need to be careful of before taking advantage of this statute, particularly making sure that New Yorkers are not being taken advantage of by a third party, making sure there's no capacity issues. I'm certainly happy to answer any questions that anybody may have. We'll keep everybody updated as this continues to move through the legislation and is signed by Governor Hochul and when it becomes effective. Thank you.
Thank you, Lindsay, for your overview. We don't have any questions today in the Q&A box, so we will wrap up. Thank you, everyone, for tuning in to the webinar. We have the contact information for all of today's presenters on the screen, so please feel free to contact any of us with any questions. Gabe will be hosting the webinar next week on September 2nd. Please join him if you're able to do so. Have a great rest of the day and a great holiday weekend. Thanks so much, everyone.